This video explains forms and practical details about both types of contempt cases. The last part of this video covers the 3 elements of a contempt case the party seeking contempt must prove. The other party could win if the judge doesn't believe any one of the elements has been proven. Sometimes a defending party can defeat a case because paperwork has not been filled out correctly or the process has not been properly followed. No matter what side of a contempt case you are on, you will have something to learn from this video. Open a new browser tab and download JDF 1816 Verified Motion and Affidavit for Citation for Contempt of Court from the Colorado Judicial Branch website at www.courts.state.co.us. Once you get to the website, click on the Self-Help Forms tab and look under the Divorce and Family Matters section. You can also use the Forms search box to look for the form by number. There are additional JDF forms needed to file a contempt case. We'll discuss these other forms later in this video. Once you have downloaded a JDF 1816, fill out the caption at the top of the form in the exact same way the other documents in your case were completed. If you were the co-petitioner or respondent before, put your name next to co-petitioner/respondent, even if you are the one filing the contempt case. Immediately below the caption, write your name where it reads I, and then add the other party's name in the appropriate space. Everything you write on the form must be the truth. Go to the number 1 on the first page of the JDF Form 1816. Get a copy of the court order that was previously issued by the court, meaning the one you think the other person is disobeying or has disobeyed. Read the order carefully and make sure that the order says what you are expecting it to say. It is the most recent order that hasn't been changed or stayed since it was issued, see number 5 on page 2 of the JDF Form 1816, and it is signed by the judge. If you are filing a contempt case, it's critical that the order actually says what you think it says, and that it is a signed and valid order. If you cannot find an order where the court has told a person to do what you think they are required to do, go no further. If you continue and you tell the court that the order says something that it does not, then you will have no case, and you may be asked to pay the other person's attorney's fees and costs. If everything is as you expect on the order, find the date the judge signed the order and put the date on the JDF 1816. Write a summary of the order on the lines below. Also, make a copy of the order to file with the JDF 1816. Don't ignore or skip any of this. If you can't prove the existence and validity of the original order, your contempt case will fail. If you are defending yourself in a contempt case, consider whether the other party has proved the existence of the order you are being charged with violating. If the order has not been proven, you may defeat the contempt. The place where you tell the court that the other party knows about the order is in the number 8 of the form JDF 1816. Whether you are asking for remedial contempt or punitive contempt, each section under number 8 requires you state that the other party knew about the order. Is this true? If so, how will you prove it if the other person says they didn't know what they were supposed to do or didn't know about the order? The court may have it on record if you were both present in the court when the order was issued. There may also be court records of when the order was sent to both parties or to the lawyers of one or both parties. This is especially likely if the court approved an arrangement signed by both parties. But if only one party participated in the proceedings when the order was issued by the court, the question about whether the other party knew of the order is important. A court will not make someone responsible for a court order they did not know about. Go to the number 2 on the first page of JDF Form 1816. If you are filing the contempt case, use this part of the form to explain what the other person has done or not done that is a violation of the court order. Reread the order you referred to in number 1. Is it clear what the other party was required to do, what the other party did or didn't do, and that the other party's conduct is a violation of the court order. Number 6 on JDF 1816 states the claim that the order has been disobeyed. Use number 3 and 4 on the first page of JDF 1816 to provide additional information about why the court should believe there has been a violation of the order. If you are filing the contempt case, explain why you think the person has the ability to comply with the order, number 3. For number 4, explain how the order has been violated in the past. What you say for numbers 3 and 4 can help the court decide whether to grant your request for the court to issue a contempt citation. If you are defending the contempt motion, reading through the numbers 3 and 4 on the completed JDF 1816 form will help you understand the case being made against you. Use number 8 on JDF 1816 to tell the court whether you want the other party to be forced to do what the court order said, remedial contempt, or whether you want the other party punished for a failure to obey the court order, punitive contempt. You can ask for both types by checking both boxes. If you check the box for remedial contempt, make sure you also check at least one of the 3 boxes below the remedial contempt box, or you will not be asking for anything. Most people check the first 2 boxes. If you check the third or other box, be very specific in describing what you want. If you don't give the other party proper notice of what you are asking for, the court will not be able to order the other even if you win the case. This is discussed in more detail later. Read everything on JDF 1816, not just the words you write, but the entire form, including pre-printed words. When you sign the form before a notary or a court clerk, you will be swearing that it's completely true. Now is a good time to read Colorado Rule of Civil Procedure Rule 107, especially sections 6C. In summary, you make it appear to the court that an indirect contempt of court has been committed when you complete and file JDF 1816. Make a few copies of your completed JDF 1816 with the attached court order before you file it with the court. Once you file it, it will become a motion. If your motion convinces the court that the contempt of court may have happened, the court will respond by issuing an order to the clerk to issue a contempt citation. In some courthouses, you will have to complete a proposed order for the judge to sign by filing JDF 1817, along with your motion JDF 1816 with the court. When the judge signs the order for the contempt citation, the clerk will complete the citation with a suitable court date and return copies of the citation with a court date on it to you. The contempt citation requires the other person to appear and defend your statements that they have failed to comply with the court order described in your JDF form 1816. The reason you must keep copies of your completed JDF 1816 is that you must include one copy of the form you filed with the court with the attached court order you allege has been violated, together with the new court order and citation when you have the other party served. These papers have to be personally served to the other person. Service on the defending person must occur at least 21 days before the court date. If you want to know more about service of process, search Adams County Justice Center on youtube.com. Scroll down to Service of Process and watch the video. Even though the video was produced for Adams County, service of process is the same no matter what county you are filing in. It is strongly recommended that you ask a deputy from your local sheriff's office or a professional process server to serve your papers on the other party. This is partially to keep everyone safe in what can be a tense situation. Mostly, this is because the rule is complex as far as how service of process has to happen. If the other party can convince the court that service was not completed properly according to the rules, you may have to start over.